Hey, okay, so I wanted to talk about this video that I found by a YouTuber called Moon Channel, and they basically go into the topic of why emulators are legal and how that relates to the Dolphin Nintendo lawsuit. I think this video can give better context on that situation, but I feel like he's misunderstanding how emulators work and how that applies to the law. And let me be clear, I'm not a lawyer here, but I'll get into it as we go. But I do have a document open here that I feel will also be pretty helpful. That I think shed a bit more light. And I don't think he did this with any malintent. I could probably associate two cases where he would be making this kind of video. One, he's either presenting himself as a hypothetical lawyer for Nintendo because he is a lawyer. Two, and this is the more realistic version, is he doesn't entirely understand how emulators work, how emulation comes from reverse engineering, what ROMs legally are, so on and so forth. And I think if he understood that, I think he would be able to make a better case in his argument. Okay, so I'll start.
On May 27, 2023, the Dolphin Emulator Foundation announced that the Steam release for their Dolphin emulator would be indefinitely postponed. The reason cited for this postponement, as per the Dolphin website, was this: we, meaning Dolphin, were notified by Valve that Nintendo has issued a cease and desist, citing the DMCA against Dolphin's Steam page, and have removed Dolphin from Steam until the matter is settled. On the surface, the matter appears straightforward. Dolphin is making something that Nintendo doesn't like, an emulator, and Dolphin wants Valve to distribute their emulator via Valve's distribution platform, Steam. Nintendo, in response, issues a cease and desist pursuant to the Digital Millennium Copyright Act to take down the emulator, and Valve complies. However, despite how straightforward this may all seem, the reality is complicated.
Okay, so it's actually not that complicated, and I'll get into that. But I think from the perspective he's looking at, it is very complicated. And it is complicated to justify emulation.
Our story is a tale of two companies, but of three actors. On one side of the field we have Nintendo, a massive publicly owned company, which possesses some of the world's most valuable intellectual properties. And on the other side of the field we have Valve, a privately owned company responsible for Half-Life and its derivatives, the Steam Deck, and the largest digital distribution platform for PC gaming, Steam. Caught in between these two behemoths is the Dolphin Emulator project. Dolphin is, as we stated, an emulator. It's software that can mimic the capabilities of a video game console. In this case, Dolphin emulates or reproduces the Nintendo GameCube and Wii consoles, allowing one to play GameCube games or Wii games generally in the form of digital copies of said games called ROMs, which is short for read-only memory. Despite its complexity, however, the Dolphin emulator is completely free to download and use. The Dolphin emulator project is completely open source and has over 200 contributors as per Dolphin's own FAQ. Dolphin's internal analytics showed that it had over 50,000 users in 2017. That number is likely substantially higher as of 2023, at a zero maybe. Now Mooney, I can hear you ask, can Dolphin just take Nintendo consoles, remake them, and then release them for free? Isn't that illegal?
No.
You might be surprised to hear this, but the law around emulation is not nearly as settled as you might think. If you enjoy using emulators or are plugged into the dialogue around emulation, you might have heard that emulators are legal.
I'll get into that. That's actually, I'll actually show how they are legal.
I might have even said as much in another video, and a quick search online seems to confirm that. Every non-lawyer source states in their articles on emulation that emulators, the console mimics, are legal, but ROMs, the game mimics, are not. Let me ask you though, what are emulators legal pursuant to? In other words, it's great that everyone believes that emulators are legal, but why are they legal? What is the basis for their legality? Well, there's no act of Congress protecting emulation. There is no Supreme Court ruling protecting emulation.
That's true.
And we've seen how even Supreme Court rulings aren't exactly ironclad protection. No. Emulation is protected by a single precedential ruling in the Ninth Circuit Court of Appeals that is now over 20 years old.
And that companies are
that
scared
merely
of.
interprets a narrow clause in the DMCA. Sony Computer Entertainment Incorporated versus Connectix Corp. Connectix Corporation was a software and hardware company notable for developing Virtual, a hardware device that introduced virtual memory to Mac OS many years before Apple itself would do so. In July of 1998, Connectix began development of the Virtual Game Station, a PlayStation emulator for Macintosh consoles. To create this Virtual Game Station, Connectix reverse-engineered the PlayStation's BIOS firmware, commercially releasing their emulator in January of 1999. In response,
I'll explain how that's relevant, but that's not entirely relevant to why emulators are legal.
to the emulator's release, Sony filed a complaint alleging that Connectix had violated Sony's intellectual property rights, including but not limited to copyright infringement. The lower court, the district court, initially held in favor of Sony, awarding Sony an injunction that blocked Connectix from copying or using Sony BIOS code to develop their emulator, and from selling the emulators they had developed. Connectix appealed the ruling, however, and
Because of the
Sega
Sega ruling in the previous.
Connectix, a great result for emulation, surely. But here's the kicker. The scope of the ruling was pretty narrow. Here's what the Ninth Circuit ruled, and take note of this, as this is arguably the strongest legal framework we have to support the legality of emulation.
Actually,
In
they're
other words,
stronger. I'll
this
go
is
into it.
The court's argument in consideration of each of the elements of fair use. Number 1. The nature of the copyrighted work. How much copyright protection does PlayStation actually have? Well, PlayStation firmware, and thus we can assume other console firmware, falls under a lesser degree of copyright protection that allows for examination and use of the examined code.
Actually, it doesn't.
You can look behind the curtain, see how the PlayStation is put together code-wise, and copy parts of it, but not the whole thing, to make something of your own.
Okay, so here's where it gets wrong. BIOS firmware is ROM data. A BIOS is a ROM. It's not like it's software to manage software. So when you reverse engineer it, you're not going to get much more than assembly code, and that assembly code isn't going to make much, it's still not going to make much more sense to your average computer. Nor is it really going to help you play games because it requires those specific computer components that are not available on a normal PC, that would be available on a PlayStation, that would be available on whatever console you want to play your game on.
Number 2. The amount and substantiality of the portion used. How much and how often did Connectix use infringing copyrighted materials? Well, pursuant to number 1, the answer is none. PlayStation has a lesser degree of copyright protection, thus the code pulled from examination of the console and used is not infringing.
And here's how I want to go into it. How this basically works is you have a console. This is a CPU. And this is your PC's CPU. We'll say GCPU for game console CPU. And we'll say PCPU for personal CPU, which is your average PC computer. Now let's say that GCPU has and PCPU have the same text system. Let's say we want PCPU to output the words hello, and we also want GCPU to output hello. Let's say that PCPU's way of outputting hello is by writing a specific number, like 1, 2, 3, 1, 2, 3, 4. And when you run 1, 2, 3, 4, it will output hello. These two are equal. However, let's say that GCPU outputs hello by going 1, 3, 2, 4. And that equals hello on the console. See, these numbers are very different and they output very different ways, so I could not run 1, 3, 2, 4 and get the same hello. That's just not going to happen. That's not how the console works because it's a different CPU, it's a different set of instructions. What emulation does is it has a translator and it recognizes, okay, So this console wants to run 1, 3, 2, 4. I recognize a command that is similar on the pCPU called 1, 2, 3, 4. And I will translate that, and that will output hello. That, in short, is how emulation works. A BIOS is another set of layers that runs into this that helps manage stuff. So game picker, your software detection, even anti-piracy measures. Those will all be managed around the components of the game console itself. But these components will not be available in the computer because they do not exist on the computer. That's what emulation is. And so this has nothing to do with the BIOS. However, if you reverse engineer the BIOS, you can understand how the console works better, because that is the closest thing to the hardware itself. It does understand how the hardware works a bit more than, say, the game itself, the game you want to play.
As such, the final product contains no copyrighted infringing material. Number 3. The purpose and character of the use. What was the copyrighted material used for? Well, if the court already says that your console has a lesser degree of copyright protection, and that as such there is no infringement, the best argument you can make here is that Connectix infringed upon your copyright by making intermediate copies that were infringing while working on the non-infringing emulator. The court held that making sense.
This is another part. Consoles themselves do not have copyright. The brands themselves do have copyright. The name PlayStation does have copyright, so you can't just make an emulator and then just call it PlayStation. That would be copyright infringement. However, hardware is copy protected under another type of system, the patent system. That system does not mix with copyright. And so if you were to make a system that worked compatible with the software, you would not be breaching that patent because copyright doesn't apply to patents. It's not used on patents. They're their own separate thing. And even in the case of software patents, you can't patent an emulator because emulators already are widely spread and widely exist. They're kind of genericized now. There's no way to software patent an emulator now because it's too late.
That intermediate copies prevented wasted effort, which is one of the very purposes of fair use. In other words, nothing was wrong here either. And finally, number 4, the effect of the use upon the potential market. How badly does this emulator affect Sony's business and/or the market at large? Well, the court found that since the virtual game station emulator allows for PlayStation games to be played on a Mac, the competition presented by Connectix is legitimate. In other words, although Sony seeks control over the market for devices that play games Sony produces or licenses, the copyright law, and I quote, does not confer such a monopoly. And if you recall the Sega video, you might remember what aspect of intellectual property does confer such a monopoly, the answer to which is patents. We'll get to that later.
Exactly.
The court also touched briefly on a trademark issue in this case, noting that the virtual game machine trademark did not substantially dilute the PlayStation trademark.
It doesn't.
So that was a pretty dense section. Let's break that down into its simplest terms. This ruling allows you to reverse engineer a console to make an emulator. It allows you to use but not completely.
It allows you to reverse engineer the software and the hardware.
Copy copyrighted BIOS software in the process. And this
you can use BIOS data as reference. That's the thing. You cannot use BIOS in the emulator because it is copyright protected, because it is a ROM. It is a ROM.
Ruling allows you to sell that emulator without infringing upon a trademark. Now, a few of you in the audience might have been quite confused when I cited to Sony v. Connectix as the single foundation for emulator law, as there is a lot of mistaken understanding that emulation protections actually derive from a different Ninth Circuit decision in Sony versus Bleem LLC.
There's actually more.
Bleem is somewhat famous, after all, for winning an emulation lawsuit versus Sony, isn't it? Well, that lawsuit really didn't touch very much upon the legality of emulation itself, even though emulators were implicated. And the Bleem case cites directly to Connectix, stating, and I quote, "We have already ruled that the emulator is not a violation of the copyright law. See Connectix." In the midst of all that law and analysis, did you manage to understand what is legal, what isn't legal, and what still remains unclear? Well, let me break it down for you in the clearest and simplest terms that I can. For emulators, it is legal to reverse engineer an emulator pursuant to fair use. You can make copies of software for development purposes too.
No. Creating an emulator is not reverse engineering. Creating an emulator is creating a software compatibility layer. Reverse engineering is a part of the creative process. It's not the process itself. Creating and distributing an emulator alone is a software development. It's a software copyright.
You can ostensibly play a game for a console
you can make a software translator
on an emulator if the latter is also legal. And you can also sell an emulator if you do so very, very carefully. As we saw with Bleem, and we will see in a later example, even if you do everything right legally, you might still run into some opposition and you won't necessarily prevail commercially. It is illegal to reverse engineer emulators that use the whole code of the original console BIOS, and arguably also illegal to use an ill-defined, large enough chunk of that original console code. How much triggers that?
A console does not necessarily have code entirely in it. You're not differentiating between hardware and software. Emulators are software. Consoles are hardware. So you can have the quote-unquote final product be the emulator and be a Wii compatible device. You just can't use the Wii name. You can't use the Wii BIOS. And that's the thing. Keep the BIOS and the console separate. They're completely different elements, and they interact with each other, but they're not necessary. And in fact, you can make your own BIOS for the Wii if you want. There are people who have done that, I think.
That large enough is uncertain, and it is unclear as to whether it is legal to use an emulator even with legally owned software.
It is. I will get into that, but to make it simple, there is a reason that Steam itself is running Proton. What Proton is a Windows emulator for Linux. You can run Windows games on your Linux computer. In that case, the emulation is not of the hardware itself, and so you do need to be a bit more careful, and this is where this story would actually hold true, is you gotta avoid copyright infringement with code and stuff. Because it's a kernel. You're emulating a kernel, you're not emulating hardware like you normally would. And so Wine and Proton would be a bit more of a gray area, whereas hardware emulation, emulating a Game Boy, recreating a Game Boy, recreating an NES and Atari 2600 would be fully legal because you're not breaching any patents by software recreation, and you're not using any BIOS data. And that's the thing, you can't use any BIOS data. You can make your own. You can very much make your own. There are exceptions. If you can legally obtain the BIOS, then the BIOS can be installed on the console itself. RPCS3, I think that's what it is. It's a PS3 emulator. You can get the BIOS off of the official website. You can install it on your emulator and it will work. It is fully legal to do that. Because even if it does recreate the hardware, you are still obtaining the BIOS legally. You are still not in breach of copyright.
In other words, it's legal to create an emulator by reverse engineering. It is illegal to create an emulator by outright copying code, and it is not legally clear whether you, the gamer, can use the emulator, even with software that you physically owned and legally purchased. And for ROMs, it is legal to download and use public domain ROMs only. It is illegal to download and use so-called active ROMs, and here's where we dispel an enormous myth of emulation. It is not legal to play a ROM of an active IP game if you downloaded it, even if you own the game itself. If you downloaded the ROM or received the ROM from a friend and played it, you have broken the law. What is not as clear is whether or not you can make a backup of a game that you already own. Even
This is actually a weird situation. Usually these come in license agreements. They're not always. And some of this has come from the music industry as well. You can make a copy of your own if it's for personal use only. As long as you do not redistribute it, it's still kind of unclear, but no one's gonna know. It's your property.
that isn't necessarily legal. If you own a copy of, say, The Lord of the Rings, The Battle for Middle-earth 2, Rise of the Witch King, and you make your own backup copy of that game and choose to play it, that might be legal, but it isn't necessarily.
There is another area in which you can qualify emulation as fully legal. If you are in any way able to make the software, the physical media itself, connect to your PC, and then run that through an emulator, you are legally able to do so. You're not making any copies, and even if you're running the ROMs, it's still, you're not making any copies. There's no copyright infringement, so there's no.
If you downloaded the game but did not make your own copy, you have arguably broken the law as we currently understand it to be. But wait, I hear you say, what about the Digital Millennium Copyright Act? Wasn't the Ninth Circuit ruling of Sega vs. Accolade codified in the DMCA? Well, first and foremost, I'm impressed that you remembered all of that from the Sega video, but the answer is yes and no. The DMCA was codified in 1998, and it provides the language protecting reverse engineering to some extent. The Bleem case and the Connectix case both came after, in 1999 to 2000, and these cases distinguished this clause, 17 USC section 1201F. If you're curious, I'll link it in the description, and helped to clarify our understanding of this clause, but the DMCA itself contains no further assistance with regards to emulation per se. There has been an uneasy peace. Nintendo still deeply believes that emulators are illegal, and it has every incentive to prove that they are, as does Sega, as does Sony, as does Microsoft, as does Valve.
Sega's a little bit of a different story. They do use emulation. They do offer games for free with that emulation. They actually don't really have much of a problem with emulation. They're pretty chill about it.
However, nobody wants to push the big red button, because if you do, you may disrupt a status quo that is generally favorable for you. Sure, you could win, but how big of a hole is emulation in your profit margins really? Emulation is an existential threat, but not a meaningful present danger, and so it can be somewhat ignored. The cost of losing and having the DMCA expanded to include protection for ROMs, perhaps, is enormous, potentially industry
It's because you
destroying.
can't get rid of it.
And so even if the chance of the big corporations losing the legal battle over emulation is slim, they have kept away from pushing the big red button, as the risk is not generally worth the reward. There have been some close calls, though, where matters regarding emulation were nearly brought to court. Take, for example, and I bet you didn't see this coming, the story of the Soulja Boy console. Soulja Boy is a Chicago-based rapper, notable for being off in it O. In late 2018, Soulja Boy released a series of video game consoles dubbed the Soulja Game Console and the Soulja Game Handheld.
No, I'm skipping over this. This is awful.
This in place forthcoming. Not everything was indeed legit. A lawsuit alleges the existence
Yeah, I know, that was a bad copyright infringement situation.
And choose wisely. The law surrounding emulation is balanced on a very precarious cliff, and the industry is waiting with open jaws below for the final push to happen. The big red nuclear lawsuit button is on the table and the glass has been lifted. Nintendo has made it clear to us all that they are ready to go all the way. Valve has also made
Oh
it
wait,
abundantly clear that they are not willing
there's
to step up
another
to the bat for
area
Dolphin. Quite the opposite.
because
They're
it makes
tacitly
clear
limited
Nintendo's
in
argument.
scope. What is the scope? Let's go back and read it again. Wii and Nintendo GameCube game files or ROMs are
Perfect.
encrypted using proprietary cryptographic keys.
I'll get into that. That's another important thing, and this is the real reason.
Keys without Nintendo's authorization and decrypting the ROMs at or immediately before runtime. Thus, use of the Dolphin emulator unlawfully circumvents a technological measure that effectively controls access to a work protected under the Copyright Act.
Usually this would be
Nintendo
considered
isn't making the
illegal, and
argument
I'll
that
go
the
into it.
emulator is an illegal act of reverse engineering. Nintendo is completely circumventing the reverse engineering issue that caused Sega to fail against Accolade, and Sony to fail against Connectix. Nintendo is dodging the 1201F trap. Instead, Nintendo is arguing only that Dolphin's use of the encrypted keys is copyright infringement, not protected by fair use, as the use of these specific encryption keys can only be used for circumventing technological measures that Nintendo has put in place. But wait, there's more. This paragraph continues, stating, distribution of the emulator, whether by the Dolphin developers or other third-party platforms, constitutes unlawful trafficking in a technology that is primarily designed or produced for the purpose of circumventing a technological measure, pursuant to 17 U.S.C. Section 1201A2A. This argument here puts Valve on the hook. If you publish this emulator on Steam, you are trafficking in a technology designed to circumvent a technological measure. In other words, you are distributing our encryption codes, and that's a violation of the DMCA. Let's continue now towards the end of the letter. The technological measures on Nintendo's consoles and games are essential for Nintendo to protect its intellectual property from piracy. When those measures are circumvented, Nintendo and third-party game developers suffer tremendous harm, because, for example, individuals can then use the emulator to play pirated games. Other commercial platforms have recognized these concerns, and as an example, we understand Microsoft recently took various emulators, including Dolphin, off its Xbox store. In this paragraph, Nintendo corroborates our understanding, but also offers another interesting tidbit, and that is this. There is industry solidarity against emulation. We've seen Sega stumble against Accolade, and Sony stumble against Connectix.
What about the Wii Virtual Console? That had the Sega Genesis, that had the Super Nintendo, that had the Game Boy, that had basically everything. It wasn't Wii compatible. None of those games were Wii compatible, except the GameCube. That's the only exception where it wasn't emulation. Those were all emulators, and those were legal because of the license agreements. They're trying to monopolize emulators. They're not trying to get rid of emulators.
At the time, the other developers were interested in the outcomes of these cases, but there was very little cooperation. Now, however, the situation is totally different. Microsoft, Sony, and Nintendo might be competitors, but they are all united against emulation. The final paragraph of the letter says this: we specifically request that Dolphin's coming soon notice be removed and that you ensure the emulator does not release on the Steam store moving forward. Pay close attention to this next sentence. This letter is not intended to be a complete statement of Nintendo's legal position or the relevant facts and law, and nothing contained in this letter is intended to or does constitute a waiver of any rights, claims, remedies, defenses, or positions of my client. The letter ends by noting that Nintendo is happy to discuss in more detail if any questions arise. This letter gives us some hints, as we discussed, about what Nintendo's legal theory might be if the emulator issue is brought to court. Before we close our discussion of the letter, though, let's do something together that you may have never done a single time in your entire life. Let's read the footnotes. Aside from Nintendo arguing that Dolphin's use of Nintendo's encryption keys constitutes a violation of the DMCA pursuant to 17 U.S.C. 1201A1, Nintendo also argues that Dolphin violates subparagraphs A2B and A2C, as well as each parallel provision in Section 1201B1. This isn't anything too new, but it does show us more of the legal framework being developed here. A2B states that no person shall traffic in any technology that has only a limited commercially significant purpose or use other than to circumvent a technological measure.
But it doesn't.
A definition that an encryption key fits pretty well. And A2C states that no person shall traffic in any technology that is marketed.
It has a very significant commercial purpose. It has the ability to run Wii games.
by that person for use in circumventing a technological measure that effectively controls access to a work protected under this title. Remember, Nintendo's scope is limited to the encryption keys here, and as such, this could potentially be a very, very strong argument against Dolphin.
But the console is
But
more than
there's one
an
little,
encryption key.
tiny, nasty surprise in this. Number one, that much of the law around emulators is unsettled. Number two, that the protections that emulators do have are largely limited to reverse engineering. Number three, that Nintendo issued a cease and desist and not a formal takedown. Number four, that Nintendo's reasoning behind the cease and desist is designed to not be snared by the reverse engineering protections, is operating in that legal gray area for emulation and has a strong chance of succeeding. And number five, that Nintendo is making preparations for a potential litigation in some manner. So we've talked about emulators in Dolphin and we've talked about Nintendo. But there's still one party here whose motives we haven't discussed yet. And that party is Valve.
I think that's enough for now. We're gonna get into this document. Because what this is this was released in 1995. And this was a document on software compatibility. The principal reason copyright lawyers perceive a big difference between user interface and internal interfaces is because these lawyers can see user interfaces of programs where they generally cannot see internal interfaces. Since copyright law has traditionally focused on protecting visible things such as text and images, copyright lawyers can more easily analogize user interfaces to that with which copyright has ample experience. The Borland decision. Here we go. This is the real reason emulators are legal. Compatibility was an issue in the Lotus vs. Borland case, where Borland's Quattro Pro product offered user choice using its native user's interface or an emulation interface that contained the Lotus command hierarchy. This is exactly how emulation works. It takes the needs of a software and provides those needs through compatibility layers so they can run on the proper hardware or software. This is how an emulator works. Borland offered the emulation interface so that users familiar with the Lotus interface could execute macros they constructed in Lotus 1.2.3. So your own software was to be intercompatible with this Borland product. The emulation mode had different looks than Lotus 1.2.3 because it uses pull-down menus to display these commands rather than the two-line command menu across the top of the screen that Lotus used as a display. Lotus argued that copying the 1.2.3 command hierarchy was an illicit appropriation of expression because the program designers had exercised creative judgment in selecting this set of commands terms and arranging them in a particular manner. This is exactly the legal issue that emulators face. Basically, can your console's zeros or ones be made to be detected and run on a computer? Creativity in selection and arrangement of words or other data has often been protected by copyright law. Program compilations, Lotus argued, should not be treated any differently for copyright purposes than other compilations would be. Borland's principal defense relied on Judge Keaton's own characterization of the Lotus command hierarchy in his Lotus versus Paperback decision. In the earlier decision, Judge Keaton stated that the command hierarchy of Lotus 1.2.3 was a fundamental part of the functionality of Lotus macro system, given the copyright statute says even when embodied in a copyright work, such things as a system and methods of operation cannot be protected by copyright law. Borland argued it had copied ideas, not expression, from the Lotus program. Judge Keaton rejected Borland's defense, in part because Lotus had designed the command hierarchy before it had designed the macro system. He also did not regard the Lotus macro system as the kind of system that Congress had meant to exclude the scope of copyright protection by the statutory. provisions on which Borland relied. In mid-March 1995, the First Circuit Court of Appeals overturned Judge Keaton's ruling. The court agreed with Borland that Lotus command hierarchy was unprotectable by copyright law, although it offered a different reason for reaching the same legal conclusion. Borland's defense had emphasized the role of the command hierarchy in achieving macro compatibility. The appellate court decided that the Lotus command hierarchy was an unprotectable method of operating a computer. This is a more general ruling than that which Borland argued. That's good. It's not a matter of reverse engineering or the creation of an emulator. It's the existence of an emulator, the ownership of an emulator, and the functionality of the emulator which is legally protected by this Borland case. Under this ruling, all program command hierarchies would be unprotectable by copyright law. The appellate court likened the Lotus command hierarchy to the buttons used to control videocassette recorders. Users operate VCR machines by pressing one or more buttons that display the labels such as play, record, fast forward, reverse, and the like. As the court observes, that the buttons are arranged and labeled does not make them a literary work, nor does it make them an expression of the abstract method of operating a VCR via a set of labeled buttons. Instead, the buttons themselves, the method of operating the VCR. When a Lotus 123 user chooses a command, either by highlighting it on the screen or by typing its first letter, he or she effectively pushes a button. Just as one could not operate a buttonless VCR, it would be impossible to operate a Lotus 123 without employing its menu commands hierarchy. Thus, the Lotus command terms are not equivalent to the labels on the VCR button, but are instead equivalent to the buttons themselves. That is, the Lotus command terms are integral parts of the method of operating a computer. See a pattern? This is exactly this. Exactly. You can make a compatibility layer to make these zeros and ones, translate to these zeros and ones. The appellate court characterized as absurd Lotus's view that users should have to learn several different ways to perform the same function if they use more than one program to do these functions. So this is what makes Wine legal as well. As long as you're not copying the Windows kernel, you can make Windows kernel compatibility layers that are necessary to run the software. And this is emulation by definition. Creating functions that your computer can understand that were original functions that a ROM would expect, because a ROM is a piece of software. And I think it's important that he recognizes that ROMs are a piece of software. If Borland had produced a superior spreadsheet program, experienced 123 users to continue to benefit from their own investments, perhaps the use of Lotus's menus should be privileged. If it had simply embodied the Lotus menu's independently written program without improvising on it, as Paperback Mosaic had arguably done, perhaps the use should not be privileged. Judge Bowden recognized that this sort of privilege would raise problems of its own, such as deciding what constitutes an improvement. He also had reservations about extending copyright protection to a de facto standard of element of a software product. On balance, he decided the major opinion's rationale was as good as, if not better, than the other options within the reach court. Some solutions, such as providing very short copyright protections for menus, were options open only to Congress. Those concerns about internal company issues watched Lotus versus Borland very closely for two reasons. First, the method of analysis used by Judge Keaton in the Lotus versus Borland case was one that, if applied to internal interfaces, would likely make many of them protectable by copyright law. This would endanger the strength of precedents such as those discussed in the next subsection that have held that internal interfaces are unprotectable by copyright law. Second, the macros users construct in the Lotus 123 command language are in fact programs. For the purpose of these macro programs, the Lotus command hierarchy constitutes an interface specification for program-to-program interaction, thereby blurring the usual legal distinction between internal compatibility and external compatibility considerations. The Borland case here is a very significant case because it basically legalizes emulators. It's not just a matter of Borland had a thing they called an emulator. This was a software compatibility layer for a set of commands which were offered by one product that were graciously added to another product to improve compatibility, to allow compatibility. And Lotus had no copyright over it. And now we get to the last part, where we go into the Dolphin situation with their and I'll go into why this is what happened to Dolphin on Steam. What about the key? This was recognized as the de facto issue by Moon Channel. Over the past few weeks, a lot has been said about Dolphin, including the Wii common key. The Wii common key being the decryption key. As you may know, Wii games are encrypted, and the Wii uses the common key that is burned into the console to decrypt Wii discs. Wii software does not have any access to the key whatsoever. However, some smart engineers and a pair of tweezers was all it took to extract the key. The extraction of the Wii common key did not elicit any kind of legal response from anyone. Nintendo did not go after Team Tweezers, the original people who got the decryption key and distributed it. It was freely shared everywhere. Freely shared. Let's see. The Wii common key, right here. And eventually made its way to the Dolphin codebase more than 15 years ago. 15 years and Nintendo did nothing. These keys have been publicly available for years and no one has really cared. US laws regarding this has not changed, yet a lot of armchair lawyers have come out talking about how foolish we were to ship the Wii common key. Fueling this, Nintendo's letter to Valve, which cites anti-circumvention provisions by the DMCA, particularly because Dolphin has to decrypt Wii games. This sounds extremely bad at a glance, and we certainly had a moment of panic after first reading it, but now we have done our homework and talked to a lawyer. We are no longer concerned. We have a very strong argument that Dolphin is not primarily designed or produced for the purpose of circumventing protection. Dolphin is designed to recreate GameCube and Wii hardware as software, and provide the means for users to interact with this emulated environment. Only an incredibly tiny portion of our code is actually related to circumvention. Additionally, GameCube games aren't actually encrypted at all. Dolphin can play homebrew and is used in development of game mods. There are even homebrew and mods that specifically target Dolphin as its own platform. Given that it has the ability to emulate more memory and more processing power than is possible on the original console, that's why there are Dolphin modes in many modern homebrew games. Considering that only a small fraction of what we do involves circumvention, we think the claims that we are primarily for circumvention is a reach. We do not believe the angle would be successful in the US courtroom if it were ever come to that. The reason the lawyers repressing Nintendo would make such a leap is because they wish to create a narrative where the DMCA's exemptions do not apply to us, as these exemptions are powerful and wide to our favor. Of particular note for the Dolphin reverse engineering exemption in 17 USC 1201F, which states that a person may develop and employ a technology means to circumvent a technological measure or protection afforded by technological measure in order to enable identification, analysis under paragraph 1, or for the purpose of enabling interoperability and independently created computer programs with other programs. This means, in simple terms, this means you can make a software compatibility layer that circumvents. You can make a circumvention if it is for the purpose of a compatibility layer, which is what emulators are. Dolphin is independently created computer program that is circumventing Wii disk encryption for interoperability with Wii software, according to this exemption. This does not constitute infringement under this exemption even allowed distribution of information collected through circumvention like encryption keys if this is for software interoperability. The information acquired through the acts permitted under paragraph 1 and the means permitted by paragraph 2 may be available to others if the persons referred to in paragraph 1 or 2, as the case may be, provide such information or means solely for the purpose of enabling interoperability or an independently created computer program with other programs, and to the extent that doing so does not constitute infringement under the title or violate applicable law under this section. 17 USC 1201F is a significant legal protection under emulation in the US, and is why Nintendo has yet to legally challenge any emulator with the DMCA anti-circumvention clauses, despite law going into effect 25 years ago. This is what I was thinking the whole time. Companies are afraid to target this because they know they have talked to lawyers. They have a lot of lawyer experience with these issues that they can't take down emulators. It's not a matter of, oh, this tiny court has decided that software compatibility layers are legal and that's it. There are laws for software compatibility. After this situation blew up, we received many requests and even some demands to remove all Wii keys from our codebase. We're disappointed that so many people on YouTube and social media didn't even consider that maybe the team has done their research and risk analysis before including the keys, and just assumed that it was pointed out to us we would remove them. However, we do not think that including the Wii common key actually matters. The law could easily be interpreted to say that circumventing a Wii disk encryption by any means is a violation. As such is our interpretation that removing the Wii keys would not change whether exemption in 17 USC 1201 applies to us or not. In fact, we think that offloading decryption tasks onto a potential third party would make the situation worse for everyone. As such, we believe leaving the keys as they are is the best course of action. And to all armchair lawyers out there, the letter to Valve did not make any claims that we were violating a copyright by including the Wii common key, as a short string entirely random letters and numbers generated by a machine is not copyrighted under US copyright law. If that ever changes, the world would be too far busy to think about emulation. We do not believe that Dolphin is in any legal danger. I think that's where I'll end it here, because this is the end of the document anyways, but I think I made my argument fairly simple. It's a software compatibility layer. Software compatibility is legal. DMCA protects them using the we common key. All's well that ends well. Okay. Thanks for watching. Check out my other videos. They're less boring than these tangents. I think that's it. Have a good day.